Mr. Babineau.
Yes, sir. Can you hear me?
Yeah, I can hear you're in court. You got to take that skull cap off your head.
Yes, sir. I'm sorry. Yes, sir.
Okay. Now, your attorney, Miss Scott, has filed a motion to withdraw because she's no longer taking court appointments. You need to be in court in person.
Yes, sir. What I was reaching out when I reached out to Miss Scott, I didn't know anything about it until her secretary got in touch with me. And then when her secretary told me that she's no longer doing a defense attorney, I reached out to the court. The court said that the lawyer they had was supposed to be representing me a different lawyer, and the lawyer was
Yeah.
supposed to reach out to me. I
Now,
never.
oh, hold on. Are you saying that they already appointed you another lawyer?
They say they were supposed to, but no one reached out to me, Your
Normally,
Honor.
you have to be in court in person. So on the motion to withdraw, and then you have to be in person to get the lawyer appointed to you because you may have to sign some paperwork.
Okay, okay. Well, I didn't know, Your Honor, and right now at the time when the hurricane happened in Houston, my transportation is messed up. That's why when I called the court, I asked them, "Can I do the Zoom call?" Because I have no transportation right there at the moment. And she told me she gave me this number and told me yes.
Okay. Well, just you can put your mic back on mute and your video, turn your video off, and then the
Yes, sir.
court gonna start in about 10 minutes.
Yes, sir. Thank you very much.
All right. Bye. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, we have two dockets. We have our announcement docket and the motion to revoke probation docket. First case is cause number 24 CCCR 1148. Case is South State of Texas versus Kevin Ben Blakeney Jr. Mr. Blakeney, would you please come forward with your attorney? Mr. Blakeney, your full name is Kevin Ben Blakeney Jr.?
Captain Ben Blakeney Jr.
Kevin Ben Blakeney Jr. How are you doing, Mr. Blakeney?
Pretty good.
That's good, Mr. Blakeney. You're represented in your case by Attorney Brenda Mitchell. Attorney Mitchell, how are you doing?
I'm doing this best I can, Judge.
Okay. Now, Mr. Mitchell, well, the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm good, Judge. How are you?
Okay, I'm doing fine. Thanks, Max. Mr. Mitchell, would you, what's your announcement in Mr. Blakeney's case?
Announce trial, Judge.
Rob?
Yes, Judge.
Okay.
We'll get motions on file for the blood discovery.
Okay, we can set you either for October 7th or October 14th.
The 14th, Judge.
Okay, Mr. Blakeney, this case will be reset October 14th of 2024 at 9 a.m. Your attorney's gonna get you reset. Once you get your reset from your attorney, you're free to go. And you have a blessed day. And you have a blessed day as well, Mr. Mitchell. And we just praying that you recover from your. Okay.
Thank you.
All right. Mr. Mackey,
Yes, Your Honor.
you're here on two non-disclosures.
Correct, Your Honor, and Mr. Weaver is here already.
Weaver. Okay. Okay, yeah. Just one minute. This is a non-disclosure. Yeah, let me, I think, let me do this here. Okay, I mean, I already reviewed it. This is, let me do this here. This is cause number 24 CCCR, excuse me, cause number 244 CCCV 0334. Case is South State of Texas versus Brian David Weaver. Mr. Weaver is present in court.
Yes, sir.
With his attorney, Attorney James Macon. State is present with Assistant District Attorney, Attorney Andrew Hubel. I have before me a petition for non-disclosure that was filed on behalf of Mr. Weaver. Let's see. Now, Mr. Macon, I have a petition for non-disclosure that was filed by you on behalf of Mr. Weaver. And Mr. Macon, would you like to go forward on Mr. Weaver's petition?
Yes, sir.
You make it a phone.
Mr. Weaver, back when you got in trouble for the alleged offense of providing harmful material to a minor, you received deferred adjudication, is that correct?
That is correct.
And did you complete that deferred adjudication?
Yes, sir.
When did you complete that?
6 months after it was charged.
So back in 2012?
Yes, sir.
And have you gotten in any trouble since that time?
No, sir.
No misdemeanors, no felonies, nothing?
No, sir.
Okay, and are you asking the court for an order of non-disclosure for that aberration in your life? back
Yes,
then?
sir.
Yes. We have nothing further.
Okay, State, you have anything?
The only issue the state would have is the nature of the offense, but if the motion for non-disclosure is filed properly, then I believe private code is entitled to it.
Okay, the court, was gonna take judicial notice of a criminal case, that was, as cause number 290364. And in this case, it shows that Mr. Brian David Weaver, was given deferred adjudicated probation on February 14th of 2013. He was given 1 year deferred adjudicated probation for this offense of harmful material to a minor. And I have before me a deferred adjudication order dismissal that was dated September 19th of 2023, was signed by Judge Lupe Flores. Okay. Okay, so pursuant to Article 411.0716 of the Texas Government Code, it says that except as provided by subsection B, this subsection applies to the issuance of an order of non-disclosure of criminal history record information for an offense committed before, on, or after September 1st of 2017. That's subsection A, and so it directs us to section 411.0725, who is eligible under this order. Non-disclosure and dismissal under. Okay, except as provided under 4. Now, let's see. So the court is going to find that the discharge or dismissal which the defendant was placed on deferred was a misdemeanor, other than a misdemeanor described under subsection 2. Oh, 7.3. Oh. And so none of these cases, well, this case doesn't fall under the cases that are listed under section 411.074 of the government code. He didn't have no affirmative finding of family violence. He has not, let's see. History. And it says that he'll be entitled, may petition the court for an order of non-disclosure under this section, regardless of whether the person has been previously convicted or placed on deferred community supervision for another offense. Is entitled to petition and issue no orders in the best interest of justice. So, Mr. Macon, why would it be in the best interest of justice to issue an order of non-disclosure?
Your Honor,
Mr.
this was a aberration in Mr. Weaver's life when he was much younger. He's gone on to be a successful businessman, and this keeps showing up and causing him detriment and would enable him to go on and be a fruitful citizen in society.
Okay. And yeah, he's passed the second anniversary date of discharge and dismissals, which was in 2013. So this is 2024. It's long past that. That's 9 years ago. 11 years ago. Let's see. Satisfies the requirement of the petition. Okay. Hey, do you have anything else?
Just as stated earlier, Your Honor, the nature of this offense is concerning to the state, and
Yeah.
but provided that the motion is filed properly, then he's entitled to this.
I don't see that either. You said due to the nature of the case, I don't see where in the statute where it says it's
Yeah,
discretionary on the part of the court if the
Like-
person
Like I was
has
saying,
a
Judge,
certain
state
type of offense.
state was merely voicing its concern and recognizes that provided the everything stated in the motion is correct and proper, he is entitled to this.
Yeah, I think he would be entitled because there's nothing in the statute
Correct, Your Honor.
that prevents him from being entitled to it.
And
like
the fact that he's gotten in no other trouble in the last 10 years,
Mhm.
I mean, I think.
Well, that would be in the best interest of justice. I mean, that would support, that's why it would be in the best interest of justice. So, at this time, let's see. Now, I do know that in your, let's do, Mr. Macon. I noticed that in your motion, you have your petition for non-disclosure. It says that you're proceeding under section 411.02, excuse me, 411.072, whereas I think based on the code, it would be 411.0725. So are you requesting to have a trial amendment?
I do, Your Honor.
Do you have any objection?
No objection, Your Honor.
Okay, no objection, so it'd be a trial amendment. And so what we'll do, Miss, I need you to pull this case up. I need I wrote on it, but I need the civil case, and I need a clean copy, because we're gonna make a trial amendment right here.
Should we just have a seat, Your Honor?
Yeah, you can, because what I'll do, I'm gonna make a trial amendment, give it back to you, and then you'll initial it. Okay, and
Yes.
then you're gonna put amended,
Good.
first amended.
Good, Your Honor.
Okay, you're welcome. And congratulations.
Okay, thank you.
You are welcome. You can get that back to, uh, yeah. Let me show you. Well, you have, 411.072, you're just gonna change that to 411.0725. Just probably put it, and you can initial, and you can title, the petition, you can be your first amendment at the top. Okay? And what I'll do, I'll look at the order, because there's some information that, additional information that's needed in the order. And then I'll draft up the order.
Thank you.
Okay? Let's make sure. All for two.
Appreciate it.
The door is locked, sir.
That's the only one?
Yes.
Here it is.
Thanks. That's cool. Is this in, this is gonna be, they're gonna have to, this is gonna be e-file.
Just gonna put the sticky in here and you'll-
Mr. Vasquez,
Yes, sir.
you ready on yours?
Yes.
Is it a,
It's a video.
oh, it's gonna be, oh, okay, we're gonna do the, just hold on a minute, I'm working on the paperwork. Which one? But he's not here right now.
His was probably in front of her and down in one.
Okay. Just making these other client here.
She wasn't Christine Fuller? No, Your Honor, she'll be here closer to 10.
Okay, that's fine. Oh, Antonio Babineau?
Yes, sir. You can hear me?
Yes. Okay, this is cause number M326206, case of style of the state of Texas versus Antonio Babineau. Mr. Babineau, is that your full name?
Yes, sir.
Okay, now, Mr. Babineau, how are you doing?
I'm okay, Your Honor. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Babineau, your case is on the motion to revoke probation docket. On March 6th of 2024, you were appointed an attorney, Attorney Lindsey Scott. To represent you, Attorney Scott has filed a motion to withdraw in this case. And I think we mentioned it to you. I think you told the court that you had called Ms. Scott's
Yes.
office. And that
Yes,
you
sir.
found out that she had filed a motion to withdraw
Yes,
because
sir.
she is no longer accepting court appointments. Is that correct?
Yes, sir.
Okay. Now, typically what the court normally does, when a person has an attorney appointed, an attorney has filed a motion to withdraw, then when the court grants the motion to withdraw, then the defendant has three options. One option is to hire an attorney. Second
Okay.
option is to request that they be given a court-appointed attorney, and you do qualify for a court-appointed attorney based on your financial affidavit that was previously filed.
Yes,
Or
sir.
the other option is for you to waive your right to an attorney and to represent yourself. Do you understand that?
Yes, sir.
Okay. Now, the court is going to grant Ms. Scott's motion to withdraw. And so since
Okay.
the court has granted Ms. Scott's motion to withdraw, obviously you have one of those three options. And what options would you accept?
I would need a lawyer for me, Your Honor. Can the court
Okay.
appoint me a lawyer?
Okay. So what we're gonna do, the court is going to appoint you another attorney to represent you.
Yes, sir. And Your Honor?
Hold on a minute.
Yes, sir.
Matter of fact, the lawyer's here. The court is going to appoint Attorney Don Boudreaux. Attorney Boudreaux is in court. Oh, there he is right there. Attorney Boudreaux, would you come forward? Did he hear me? Attorney Boudreaux, would you come forward? Okay, Attorney Boudreaux, I just appointed you to represent Mr. Babineau. He's on Zoom. And he was previously represented by Attorney Lindsey Scott, who filed a motion to withdraw.
Yes, sir.
Okay, he has a motion to revoke probation. And so he's not here right now. And so what we're going to do now, Mr. Babineau.
Yes, sir.
What is, yeah. You had something to say?
No, Your Honor.
Okay, the court is going to reset your case for 1 week to give you an opportunity to come to court on next Thursday.
Okay.
So you need to be here next Wednesday.
I will be there.
At 9 a.m. And Mr. Boudreaux will be given information to contact you.
Okay.
And then when you get here, then we'll talk about your case. Now, let me mention this to you. I know the last time that you were here, according to the probation officer, you were required to pay your fees and complete community service. Is that correct?
Yes, sir.
Okay. And so when you come here on Wednesday of next week, that's what we're going to be going over.
Okay, no problem. Yes, sir.
Okay. So
Yes, sir.
Let's see today.
And
Okay, so it's going to be reset to August the 21st.
okay.
2024. Now, I think you had something that you wanted to say before.
Yes, sir. Yes, sir.
I interrupted you.
Yes, sir. Only thing I wanted to say was the only thing I really, when I reached out to Miss Lindsay Scott, I just was asking her for a little bit more time to finish paying the fine, and it would have been over with. But when I reached out to her, they say that she wasn't no longer represented, and I had to go through the court and wait to go to court to speak to the judge before I do anything.
Okay, well, we'll talk about that when you get here on next week.
Yes, sir. No problem. And
Okay.
one more thing, Your Honor, I do have this right here from Mr. Gillian. This right here from Mr. Gillian, the probation thing. I have that, and I did get the HEB card too. So I did do the stuff that he told me to
Okay,
do.
you just need to bring everything in with you when you come to court.
Okay, no problem.
Okay,
Yes, sir.
all right. We'll
All right,
see
thank
you on Wednesday at 9 a.m. and that date is August 21st of 2024.
Okay, thank you very much.
Okay, you're free to go and you have a blessed day.
You two have a blessed day as well.
She's gonna give you a reset.
Am I gonna be appointed on?
Yeah,
that?
you're
Okay.
appointed.
Judge, may I ask you one other question
On this case or a different case?
on a different one?
Okay, Mr. Babineau, you're free to go and you have a blessed day.
All right, you too. Thank you.
Jefferson County Court at Law number 2 is back in session. The court is in session and cause number M325344. Case of style of state of Texas versus Hector Antonio Crisanti. Mr. Crisanti, is that your full name?
Yes, sir.
Mr. Crisanti, would you please raise your right hand? Mr. Crisanti, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Crisanti, you may put your hand down. How are you doing, Mr. Crisanti?
Good.
That's good. Now, Mr. Crisanti, you're representing your case by your attorney, Attorney Alan Parker. Attorney Parker, how are you doing?
Good, Judge, thanks.
And Mr. Parker, do you waive a record
We do.
in Mr. Crisanti's case?
Yes.
Mr. Crisanti, I have before me a document on paper that is titled Motion to Revoke Probation. This motion to revoke probation was filed by the Jefferson County District Attorney's Office. In this motion, it alleges that you, Hector Antonio Crisanti, was tried on February 1st of 2021 for the offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. You were found guilty and assessed, and your punishment was assessed at 180 days confinement in the Jefferson County Jail, a fine of $750. The confinement portion of your sentence was probated for a period of 18 months. In this motion, there are 3 allegations. And state, are you abandoning allegations 1 and 3?
State's abandoning number 2 going forward on 1 and 3.
Okay, the state is abandoning allegation number 2, which means that they will be going forward on allegation 1 and 3. Allegation number 1 alleges that you, Hector Antonio Crisanti, failed to report to the Jefferson County Probation Office as ordered by the court for the months of October, November, and December of 2021 as directed in violation of conditions 4 of your probation order. Is that true or not true?
True.
Okay. Allegation number 3 alleges that you, Hector Antonio Crisanti, failed to report, or excuse me, failed to perform the community service hours required as ordered by the court in violation of condition 18 of your probation order. Is that true or not true?
True.
Now, Mr. Crisanti, are you pleading true to allegations 1 and 3 freely and voluntarily?
Yes.
And are you pleading true because they are true?
Yes.
Okay. Mr. Crisanti, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials, HC, on the line next to a box that's checked MTRP, which means motion to revoke probation, true to allegations 1 and 3. Did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document, that's titled trial court certification of defendant's right of appeal. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Crisanti, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you read and understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Crisanti, are you a citizen of the United States?
Yes, sir.
Stay up for State's 1.
No
Any-
objection.
No objections. State's exhibit number 1 will be admitted. Mr. Parker, you've advised and counseled Mr. Crisanti. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Crisanti, the attorney, Mr. Parker, has advised and counseled you. Are you satisfied with his representation?
Sir.
Has he provided full, effective, and competent legal representation?
Sir.
Mr. Crisanti, I will accept your plea of true to allegations 1 and 3. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. I'll also find that there is sufficient evidence to revoke your probation and your probation is hereby revoked. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For plea of true to allegations 1 and 3, the state is offered 4 days time served, court calls, Saxon retired.
Okay, Mr. Crisanti, State is offering that you serve 4 days in the Jefferson County Jail. You will not have to serve any more time in the Jefferson County Jail in this case because you've already served 4 days in the Jefferson County Jail. Therefore, you will be given credit for the time that you have already served. The court costs in this case will be taxed or retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed or retired. Mr. Crisani, do you understand the state's offer?
Yes, sir.
You think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Crisanti, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Crisanti, please stand in front of the court coordinator and follow the directions of the bailiff. Once you finish following the directions, the bailiff, you're free to go and you have a blessed day. Mr. Parker, you're free to go as well. You have a blessed day.
Your Honor, Ms. Fuller is here then.
Okay, let me get Mr. Lodge.
Thank you, Mr. Albert.
Yes,
Mr. Mays,
Kirsten Nicole Mays. Ms. Mays, your full name is Kirsten Nicole Mays. How you doing, Mr. Mays?
Good.
I'm doing fine, thanks for asking. Ms. Mays, you're represented in the case by your attorney, Attorney Jennifer DeLodge. Attorney DeLodge, how are you doing?
doing great.
That's good. Now, Ms. DeLodge, I see a note on the docket sheet that said Ms. Mays was assigned pretrial diversion.
Yes, Your Honor. And the only time available since the last setting was August 1st, where I happened to have a vacation letter on file and I was out August 1st. So we could not do the signing then. She is scheduled for October 1st setting.
I think it's October 3rd, isn't it?
Or, I'm sorry.
The first Thursday.
Yes, the
The
first
first
Thursday, I think it's the, isn't it? I think it's the
But
third.
she's already scheduled.
Okay, make sure you get the correct day, to go down there. When is the first?
It's first Thursday.
I gave you the date.
No, someone on the calendar. I think it's the third.
Okay.
Yeah. We don't want her to miss it.
Yeah, you're right.
Let me make sure. Yes, the third. Okay. So this case will be reset to October 14th, and you need to appear in the DA's office on October 3rd to sign the paperwork. Okay. All right. This case is reset to October 14th. You need to reset from your attorney. Once you get your reset from your attorney, you're free to go and you have a blessed day. And Mr. Lodge, you have a blessed day as well. You're welcome. Do you have anybody else? Ray? Good. Okay. Mr. Macon?
Yes, Your Honor. Your Honor, the same paralegal prepared the petition and I've gone on and corrected file amended.
Oh, same thing? Oh.
Yeah.
Okay. Okay, this is cause number 24CCCV 0181. Case is style of state of Texas. Well, yeah, the state of Texas versus Kristen. Is that Leah Fuller? How you doing, Ms. Fuller? I'm doing fine, thanks for asking. Ms. Fuller, you're represented in your case by your attorney, James Macon. Now, Attorney Macon, I have before me a first amended motion for non-disclosure. It's a trial amendment. State, you have any objections? He's amended.
No objections to, would you need my initial, Your Honor?
That's fine.
One of the reasons she's not my paralegal anymore is things like this.
Okay, let's see. Now, Mr. Macon, would you like to go forward on your petition?
Yes, Your Honor.
Okay.
State your full name for the record.
Kristen Leah Fuller.
Okay, and Your Honor, we waive a record.
Okay,
And Ms. Fuller, were you placed on deferred adjudication for the offense of theft?
Yes.
When was that? Do you remember?
2019, May,
Or
2020.
I have a copy of the deferred adjudication.
Oh,
It's in the court's file.
you didn't know there'd be a test, did you? Okay, you were placed on deferred adjudication for 1 year and in May 11th, 22. Is that correct?
Yes.
And was this a charge of theft, just kind of an aberration in your life, stealing some makeup when you were much younger?
Yes, sir.
Okay. And would this offense, were it to be disclosed to all kinds of individuals, cause you problems, and not only in work, but in your private life?
Yes, sir.
And you think it's in the best interest of you and society that a petition of non-disclosure be granted and an order prepared? Okay. And you've gotten in no trouble since then?
No, sir.
Nothing else? Okay. I have nothing further.
State, do you have any questions?
Do you also go by, Kristen Golson Fuller?
Yes, sir.
Okay.
And his name goes.
Oh, yeah.
Well, under that name, do you have a bunch of offenses or
No,
anything?
sir.
You haven't been on any crime sprees that we know of?
No, sir.
Okay.
But have you received, deferred adjudication on the theft prior to the one in 2018? I'm sorry, yes, 2018.
You get in any other trouble before?
No, sir. Yes, sir.
What do you mean by that?
Well, I thought for what. I could be wrong. I have the dates mixed up. I'm sorry, Judge.
Mhm.
Andrew, do you show something? I don't.
Need to look at the statute for just a second, but I see these two are, deferred adjudications. Back from 2009.
2009?
Yeah.
How old were you in 2009, Ms. Fuller? Okay. Anyway, they were a much younger time in your life, and you've got in no trouble.
No, sir. Yeah, so I have a house on them. So,
State, do you have any other?
The only issue I have is with, 411.0728,
11, 411.0725.
point, 0.072 A1B, Your Honor. A2, sorry.
A2. Repeat the section again.
411.072 A2.
No, what, he's not proceeding under that. He's proceeding under 411.0725.
0725. Okay. Nice.
Is that correct?
Well, then that would, the issue with that would be under 411.0725 A1.
Under A1. Okay, we're also received for this and satisfy the requirements. We may petition to elect that person. Did you see 411.0725C? Says except as provided by 411.074. A person may petition the court for an order of non-disclosure under this section regardless of whether the person has been previously convicted of or placed on deferred adjudication, community supervision for another offense.
Okay. There's no objection, Your Honor.
Okay, Miss Oh, I'm glad you brought up the point that, the middle name is Golson. Because, well, the court is gonna take judicial notice of the court's file, all of the paperwork in the court's file in cause number 322293, and in that, the information has her name as Kristen Leah Fuller, yet the deferred adjudication order of dismissal has as Kristen Golson Fuller. And, oh man, the first names are spelled different
Kristen with an E versus Kristen with
with
an
an
I.
I. Right.
You're the
And
same person.
yeah, he's the same
Okay.
person, but I guess what I'm getting at is when we sent it to, well, put it like this here. Would you like to amend your petition to say this is Kristen Leah Fuller, AKA Kristen Golson Fuller?
Yes, sir.
Yes,
Okay, let me get it back. It's because once we send the order off, it may be a little confusing if we don't have both names in it. Do you have, did I give it, you gave it back to me? Oh, here, this,
I just gave the first amended petition.
okay, let me, oh, here it is. Yes. Yeah, you have to do the AKA. Oh, let me get this to you so you know how to spell it on here.
Okay.
Okay. I'm glad you brought up that point. Is there any other places on that document where the name is besides in the caption? You may have to put it at AKA. Listen. Okay, and I'll draft the order.
I think that's a wonderful idea.
Okay, you are.
He's not gonna use this order, so just.
Yeah.
Yeah, I'm gonna draft another
I
order.
don't know if you need to do that one too, but probably not.
Okay. All right. Congratulations. You are. Down. Just see. Have anybody else?
Yeah, I'm like, saying Mr. Rojas.
Mr. Ross? Is that? Oh, that's the off docket. Alexander, that Alexander Castro?
First, one of the conditions of bond was for an interlock, so he had the interlock on this whole time.
Well, he's no longer on bond.
Right, he's gonna need an order to get that interlock off.
Well, we have the bond, the condition to reach the interlock because he's no longer on bond. Oops. Okay, hold on a minute. Two, four, C, R.
That would be a minimal.
Next month. Our seat gets stolen information. We're just trying to make room over there. We're 16.
Oh. No, this is, this.
How are you, Ruben?
No, this was GPS. That's not that's supposed to be that's supposed to be a, intoxilizer. This is some probation paperwork. This is not the. Yeah.
I'm not here now.
You need to make a copy of this? Well, okay. State, do we have a plea bargaining agreement?
Yes.
And what is the agreement?
In exchange for defendant's plea, the state offering $50 plus court costs.
Okay, Mr. Kipling, to this Class C misdemeanor, the state is offering that you pay a fine of $50. What is the court cost?
277.
Plus court costs of $277, which comes to a total $327. Mr. Kipling, would you be able to pay the fine and court costs of $327? Okay, now, Mr. Kipling, do you understand the state's offer?
Yes.
You think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Mr. Kipling, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Kipling, this will conclude your case. You're going to stand in front of our court coordinator, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you can go downstairs to the county clerk's office, and I think Mr. Boudreaux will show you where it is, and make the payment. And then once they give you a receipt, you're going to come back up here with the receipt. Okay, so please stand in front of the court bailiff. And you have a blessed day. And Mr. Boudreaux, this is your last case. You have a blessed day tonight. You're welcome. And she's going to give you that information on that client that you were appointed on.
I'm gonna serve you that appointment.
You're going to send it by.
I'm gonna e-file it and e-serve them. The appointment is gonna have next, Wednesday's date on it.
Okay.
Okay, Mr. Bridger?
That door is locked, sir. You got to go through the other door.
E-file and e-serve it, okay?
Okay, I will see it for Friday.
So you might just give it to him and you can't print it off.
Let me one of it.
But just have a seat.
Let me finish
Yeah.
making this plea, then I'll. We'll go down.
You walking in downstairs,
Yeah, let
Mr.
her go
Boudreaux?
down. It's fine.
Mr. Boudreaux, your client went downstairs. You can go tell him where to go.
Okay.
Okay, he already went outside.
You can go.
Yeah, he's already outside. You got to go outside the door to get him.
Yes, sir.
Okay,
Thank you, Judge.
okay, you're welcome. Okay, who else we have? Mr.
Lighting. Is Roy?
Huh?
Roy, that's yours?
No.
You,
Oh, okay, well, I'm the only one who forgot.
you sent somebody else?
Neither one of them, please. Going to the next person, what can I vote? Jeremy Moore and Siobhan Sylvester.
You got Morris and is Sylvester here too?
She said, yeah.
Okay, Jeremy, Jamal, Morris. Okay, this is cause number 23CCCR 1322. The case is styled State of Texas versus Jeremy Jamal Morris. Mr. Morris, is that your full name?
Yes, sir.
And Mr. Morris, how are you doing?
Are you, what about yourself?
I'm doing fine. Thanks for asking. Ms. Morris, you representing your case by your Attorney Marvin Lewis. Attorney Lewis, how are you doing?
I'm doing all right, Judge. How you doing?
I'm doing fine. Now, Mr. Lewis, what is your announcement in Mr. Morris's case?
Judge, I've been talking with the state on this matter, and Mr. Morris is currently on a federal probation, and I need to get some confirmation from the probation officer, which I should have that over the next couple of weeks, to see if we can go ahead and get this resolved with possibly what the offer is. So I'm asking for about 30 days. There should be enough time where we got to get this case resolved.
Okay, you saying possible, I mean.
Well, we have an offer now, and depending on what the answer we get back from federal probation, that may result in a different offer, so we can try to get this resolved.
That's correct, Your Honor. The state's just waiting on confirmation from federal probation to determine how to.
This week.
Okay, hold on a minute. Okay, this case is gonna be reset for September 25th
You're back by then?
Oh, yeah.
of 2024. I'll just set it on the plea docket,
Okay, no problem.
okay? Yeah, you said what? That we're setting on plea dockets.
Okay.
Okay. Mr. Marsh, we're gonna send your attorney reset. Stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day.
Thank you.
Siobhan Denise Sylvester.
She's sitting right outside.
Yeah, but it's.
Okay.
Like, sometimes they end up there.
Yeah, September
Today,
25th.
it's been so long.
Okay, this is cause number 24 CCCR 0788, case of style of state of Texas versus Siobhan Denise Sylvester. Mrs. Sylvester, is that your full name?
Yes, sir.
How are you doing, Ms. Sylvester?
I'm doing wonderful yourself.
I'm doing fine, thanks for asking. Now, Ms. Sylvester, you represented in your case by your attorney, Marvin Lewis. Attorney Lewis, what is your announcement in Ms. Sylvester's case?
Judge, we've gotten a new offer from the state that I think this should take care of it. I need to get with Ms. Sylvester on towards the fines that'll be involved. If we could get placed on the plea docket, possibly that same date in September.
September 25th?
Yes, sir.
Okay, Ms. Sylvester, your case will be reset to September 25th, 2024 at 9 a.m. Your attorney will be given notice of your reset, your attorney and your bondsman. Stay in contact with your attorney and your bondsman. You're free to go.
All right.
And you have a blessed day. And you're free to go as well,
Thank
Mr.
you.
Lewis. Okay, you're welcome. Caleb Moore. Mr. Moore, your full name is Caleb Demani Lee Moore.
Yes, sir.
How are you doing, Mr. Moore?
Good, how you doing?
I'm doing fine, thanks for asking. Now, Mr. Moore, your case is on the court's announcement docket. I have before me a document that's titled Judge's Explanation of Rights to Defendants Without an Attorney. I see that this document was signed on May 28th of 2024. At that time, you said that you wanted your case reset to hire your own attorney. Have you hired your attorney?
No.
That can come out your mouth. There's a trash can to your right, and you put it in there. Now, why haven't you hired your attorney?
Because when I said I was working at the time,
So you're unemployed now?
yes, sir, but I started working for days.
So my question to you is, you still want to hire an attorney? Or you want to see if you qualify for a court-appointed attorney?
I still want to hire one.
Okay, I'm gonna give you, hold on a minute. This is, Caleb Demani Lee Moore on page 6 of the docket. Let's see. September 30th. Yeah, yes, we'll put him on 9/25. Okay, this case is reset until September 25th of 2024. Are you gonna give him a
I'm
reset?
just gonna have a seat right there.
Okay, your case is gonna be reset September 25th of 2024. The court coordinator is gonna reset your case. Once you get your reset from the court coordinator, you're free to go and you have a blessed day.
You too.
Did you reset William Wilkerson's client?
Yes, sir. And right. I have Annie Williamson.
Yeah, Mr. Wilkerson is sick.
Ms. Williamson, case. Yeah, disposed of,
Ann Williamson.
yeah, I have Brenda Holmes, yeah.
Have we already talked on?
I don't think.
Mr.
It's not showing that she, I'm sorry. Yeah, I would have.
I'm ready, I got a plea.
No. Well, what they was asking was, had you already been out to the jail for the people for the jail run docket?
No, I'm gonna.
Okay, well, okay,
Yeah.
then she's adding another one on, this lady.
Y'all gonna send me off?
Okay, that's all we need to know.
No, I haven't been, I'm gonna go out there today.
Okay. Who else we have? Who
But
else
I
we
got a
have?
plea, I'm ready if you want me.
Yeah, no, the paperwork is not ready.
Oh,
We'll do yours next, you can do Mr. Boswell.
Vasquez is not here.
He
In
must
here.
went, he went back next door. Okay. So, she's gonna come back tomorrow?
Yes,
Okay. Um,
oh, okay. Okay. Who else we looking at Mr. Adams? Miss, Mr. Kipling? You can show her the receipt.
you have a copy? You have one for yourself?
Just, is that, it didn't,
I guess I'm, okay, she gonna miss a copy for that.
you just need a receipt, yeah. Vasquez is not here. Not back. Which one are you working on now?
I'm finishing on Mr. Vasquez, and then I'm gonna give him his receipt, and then I'm gonna do Mr. withdrawals. But that's just not simple, I gotta take Lindsay off. Then add him, it's not.
We might need to wait upon that if you can get those pleas ready.
I'm gonna do yours next. Yours is next.
Which one is that? Roy? Okay. While we waiting on Roy, okay. I don't know. Audio. He has another one too. You have, which case?
Chelsea Pugh and, Dancy.
Oh, Jermaine Dancy?
And, the state can announce on those, Your Honor.
Hmm?
The state has announcements on those cases, Your Honor.
Okay, Mr. Dancy, your full name is that Jermaine Khalid Dancy Jr.? How are you doing, Mr. Dancy?
How about you?
I'm doing fine. Thanks for asking, Mr. Dancy. You're representing case by your attorney, Langston Adams. Attorney Adams, how are you doing?
Doing well, sir.
And Mr. Hubel, you said the state has an announcement?
Yes, Your Honor. In this case is a burglary of vehicles case. The state is requesting time to contact the complaining witness in regards to restitution in this case.
Okay, so this case is going to be reset till September 30th,
That's Pew.
Dancy.
Bro,
Now, keep it on the announcement.
No, she was asking me your name. Yes. That's gonna be at 9. Your attorney, and your bond will be given notice to your reset. You're free to go. Stay in contact with your attorney about it, and you have a blessed day. Kelsey Pugh, Mr. Pugh, your full name is Kelsey Pugh.
yes, sir.
How you doing, Mr. Pugh?
Good, how are you?
I'm doing fine, thanks for asking. State, you have an announcement on Ms. Pugh's case too?
Yes, in this case, defense has applied for Beggars Intervention Prevention Program. That application is still being processed at this time, Your Honor.
Oh, I had a note here, she was supposed to sign on, June 10th, 2020. Will you ever scheduled to sign?
I don't believe so.
No, somebody got a memo in here. So she. No, we need to get this one moving. We need to put this one to bed. But this case is,
State has noticed the age of the case, Your Honor.
right. Okay, let's, how much time do you need?
I don't want to make a representation that ends up being incorrect, Your Honor.
Well, we're gonna say September, we're gonna give you September 30th, okay? So whoever in the DA's office is responsible, make sure you get them the information
Yes, Your Honor.
to, yeah, okay. That's pretrial diversion. Okay. Well, you know what? I'm gonna put this in October. Because I don't know if they do those signing dates on the same day of the regular pretrial diversion?
Yes, Your Honor.
Okay, so we're gonna put it in October 14th. Okay. Case gonna be reset to October 14th. In the meantime, your attorney and the district attorney is going to be working on a date to get you into the program. All right, to sign into the program. And your attorney will be given notice of your court date. You're free to go. Stay in contact with your attorney and your boss,
Yes, sir.
and you have a blessed day.
Thank you, Judge.
Okay, now, I see Langston has a guy, has Max Colbert.
Have them to stay in contact with
On the
the boss.
MTR.
It's on the MTRP. Is, This is cause number M 332-968. Case is filed State of Texas versus Max Robert Cover. Mr. Cover, is that your full name?
Miss Max Del Cover, yes, sir.
Okay. How are you doing, Mr. Cover?
I've been better.
Okay. Probably been worse too, I would
I've
imagine.
been worse, yes,
Yeah.
sir. I'm blessed, yes, sir.
That's right. Now, Mr. Cover, you're represented by your attorney,
Yes, sir.
Attorney Langston Adams, Attorney Adams. What is the announcement that,
This is a MTRP.
right,
And, the offer was 60 days, jail. Mr. Colbert has elected just to go to you, because he declined.
go to me on what?
Well, on the MTRP to let you decide if you're gonna continue him on probation or if you're gonna do something other than that. He's gonna, plead open to the court, basically.
Okay,
So we're ready to go right now.
okay,
Because
well,
the PO is here.
yeah. Hold on, hold on a minute. Let me see. MTRP. I still think y'all have to fill out the paperwork. The plea papers, because I'm just doing punishment. Okay,
You'll have to plead as open.
yeah, because, yeah, you have to do the plea paperwork.
You
I
just
thought
need
you
like
have
the
to make a
actual.
finding first on.
But you gotta, he's pleading true to whatever, I mean, you still have to fill out the paperwork. It's a plea. It's like an open plea. Like if we do an open plea, you fill out the paperwork, the waivers, and the trial court certification.
Yeah.
And then the only thing I'm doing is, we make the findings based on the plea and then we do an assessment of punishment.
Yes, sir.
Okay? So y'all need to, take some time to fill out the paperwork. Yeah, it's just unagreed.
Just
Okay.
unagreed as a punishment.
Yeah, y'all
Everything
can have a
else,
seat.
Mhm.
Okay.
But now you have to.
The other day. Not right. So he has, Miss Mosby. Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. Cases are Damian Knighton Jr. Cause numbers 24 CCCR 0186 and cause number 24 CCCR 0320. Both cases are styled State of Texas versus Damian Knighton Jr. Mr. Knighton, is that your full name?
Yes, sir.
Mr. Knighton, would you please raise your right hand? Mr. Knighton, do you, the other hand?
You're all right.
Mr. Hand, Mr. Knighton, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Knighton, you may put your hand down. How are you doing, Mr. Knighton? I'm doing fine, thanks for asking. Mr. Knighton, you're representing your case by your attorney, Attorney Joel Vasquez. Attorney Vasquez, how are you doing?
Good, Your Honor, how about yourself?
I'm doing fine, thanks for asking. Mr. Vasquez, do you waive a record in Mr. Knighton's cases?
Yes, sir.
Mr. Knighton, I have before me a document. Well, I have before me case number 24 CCCR 0320. And in this document, or in this case, I have an information that is on my computer. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Knighton, it alleges that you, Damian Knighton Jr., on or about December 23rd of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of theft by mail. Mr. Knighton, do you understand what you've been charged with? Mr. Knighton, to this charge, how do you plead? Guilty, not guilty, or no contest? Now, you pleading no contest freely and voluntarily? And are you pleading, okay, you have to speak up. And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Knighton, I also have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials, DK, that are on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of this same document, there's a signature above the line that is titled Defendant.
Yes, sir.
Is this your signature? The next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you are giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
Mr. Knighton, before you signed and initialed all of the documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over? Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Knighton, are you a citizen of the United States?
Yes.
Number
State,
6-1.
any objections?
No objection.
No objections. State's Exhibit Number 1 will be admitted. Mr. Vasquez, you advised and counseled Mr. Knighton. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Knighton, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Mr. Knighton, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, Do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For defendant's plea of no contest, the state has offered 1 year deferred probation with a $250 fine and 40 hours community service. The companion UCW case will be dismissed for forfeiture.
Mr. Vasquez, were you appointed in this case?
Yes, Your Honor.
What is this, court cost? He's on page 5.
277.
That's correct. What you're saying is correct. What you're saying
Okay, Mr. Knighton. The state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $250 plus a probation fee of $277. You'll be required to pay. Let me back up. You'll be required to pay a fine of $250 plus court costs of $277. You'll also be required to pay a probation fee of $60 a month, urinalysis fee, $15 a month, reimbursement fee of $15. And you'll be required to reimburse Jefferson County Court appointed attorney's fees of $250. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $154 a month. Will you be able to pay the $154 each month?
Yes.
Okay, you'll also be required to perform 40 hours of community service. You'll be required to forfeit the weapon in clause number 24 CCC Aura 0156. To the Beaumont Police Department. And I have before me a copy, well, not the copy, but I have the motion to forfeit. In that case, clause number 24 CCCR 0156. Mr. Knighton, do you recognize this document?
Yes.
Is this your signature on the line as title defendant? Mr. Knighton, before you signed this document, did your attorney go over this document with you?
Yes.
And did you read and understand everything in this document? And is everything in this document true and correct
Sir.
to the best of your knowledge?
Yes, sir.
Mr. Knighton, I will grant the motion to forfeit the weapon to the Beaumont Police Department. Now, Mr. Knighton, the state will be dismissing cause number 24 CCCR 0186 for forfeiture of weapon in that case. And Mr. Knighton, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Knighton, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Knighton, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney Mr. Bass says about the non-disclosure because he's quite competent in those matters. Now, Mr. Knighton, this will conclude your case. Just have a seat in that first chair, and when the bailiff comes back, you're going to stand next to the bailiff and follow her directions. And once you finish following her directions, you're free to go. And you have a blessed day.
I sympathize.
Thank you, Judge.
Okay, you're welcome. This is that's 16. You still working on another one, Roy? Okay. Okay. Jefferson County is in session and calls numbers 23 CCCR 2196 and calls number M333316. Both cases are styled State of Texas versus Ambrasia DeCorey Roy. Ms. Roy, would you please come forward?
Which one are you proceeding
Uh,
on?
M333316.
There's that one.
Ms. Roy, your full name is Ambrasia DeCorey Roy.
Yes, ma'am.
Ms. Roy, would you please raise your right hand? Ms. Roy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Ms. Roy, you may put your hand down. How are you doing, Ms. Roy?
Good, how are you?
I'm doing fine. Thanks for asking, Ms. Roy. You're represented by your attorney Langston Adams. And Mr. Adams, do you waive a record in Ms. Roy's case?
Yes, sir.
Ms. Roy, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, state, are you abandoning the enhancement paragraph?
Yes, Your Honor, I may need to add that to the top of that second plea
Yeah.
report.
Yeah, you didn't,
Is it on there? Just check.
no, it wasn't. Hold on, let me
Did you
see.
not check
I
deferred?
don't think it was on this.
It's a deferred offer.
It wasn't. That's-
Yeah, she didn't know that,
I'll take a look at it, Judge.
yeah. Yeah, you did, no, it wasn't on the, form, yeah. Do you have the other one ready? You go ahead on and finish that one, we'll start on that one, I guess. Now I can I do it and she can have a seat once once we've finished both of them? Okay,
I'm just writing the waiver real quick, Judge.
I can send it back to you after I finish, right?
Okay.
Oh, I'm sorry.
Okay, now Ms. Roy. I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you committed a Class A misdemeanor. However, state is abandoning an enhancement paragraph, which means you will be charged with a lesser included offense of a Class B DWI. Do you understand? Okay, now, to the charge, well, this information alleges that you Ambrosier Decory Roy, on or about September 12th of 2022, while you were operating a motor vehicle in a public place while you were intoxicated in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Ms. Roy, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Roy, how do you plead guilty, not guilty, or no contest?
No contest.
Now, you pleaded no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Roy, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. You recognize this document?
Yes.
On page 2 of the same document, there are a set of initials AR on a line next to boxes checked no contender, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? I also have before me a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Ms. Roy, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct
Yes.
to the best of your knowledge? Ms. Roy, are you a citizen of the United States?
State offer state's one.
Any objections?
No objection.
No objections. State's Exhibit Number 1 will be admitted. Mr. Adams, you've advised and counsel Ms. Roy, is there any evidence that she is currently mentally incompetent to stand trial?
None.
And Ms. Roy, your attorney, Mr. Adams, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Roy, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 15 months deferred, $500 fine, 40 hours community service, DWI education and interlock. This is also to run concurrent with clause 2.3 CCCR 2196.
Mr. Adams, were you appointed in this case?
No, sir, I'm hired.
What is this? Court costs? The second case on the 37, huh?
377.
377. Okay, let's see, Mr. Adams, your client, Ms. Roy. Okay, now, Ms. Roy, the state is offering that you serve 15 months deferred adjudicated probation. During the 15-month probationary period, you'll be required to pay a fine of $500 plus court costs of $377. You'll also be required to pay a DWI conviction fine of $100. You'll be required to pay probation fee of $60 a month, a urinalysis fee of $15 a month, and a $15 reimbursement fee. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $151 a month. Will you be able to pay the $151 each month?
Yes, sir.
You will also be required to perform 40 hours of community service, install an interlock device on any vehicle that you own and operate, attend and complete a DWI education class, have an alcohol assessment, adhere to the other standard terms and condition of probation. And this case will run concurrent with cause number 23 CCCR 2196. Ms. Roy, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Roy, I'll follow the plea bargain agreement that you have entered into with the state. Now, we don't have the other case yet.
I'm gonna have to send it to you.
Prosecutor to get back. Two three CCCR 2196, case of South State of Texas versus Ambrasia DeCarry Roy. Ms. Roy, I have before me an information that was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ambrasia DeCarry Roy, on or about September 17th of 2023, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of assault causing bodily injury. Ms. Roy, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Roy, how did you plead? Guilty, not guilty, no contest?
No contest.
Now, you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you did not wish to fight a contested charge? Ms. Roy, I also have before me a document that is titled Misdemeanor Plea of Minors, which is also labeled Stacy 71. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials on the line next to a box that's checked. Nola contender, did you place your initials on this document? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? And on the next document, that's titled trial court certification of defendant right of appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
I also have before me a document that is titled Discovery Certification on paper. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Ms. Roy, before you sign and initial these documents, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Any objections, Mr. Adams?
No objection.
No objections. State's exhibit number 1 will be admitted. Mr. Adams, you've advised in counsel, Ms. Roy. Is there any evidence that she's currently admitted in counsel to stand trial in this case?
None.
And Ms. Roy, the attorney, Mr. Adams, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Roy, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state is offering 15 months deferred, $500 fine, 40 hours community service. Defendant is to have no contact with the victim, Ashley Rollins, plus court calls, and this will run concurrent with the companion case.
Okay. What is her court cost?
277.
277. Okay. Okay, Miss Roy, state is offering that you serve 15 months deferred adjudication probation. And in this 15-month probationary period, you'll be required to pay a fine of $500, plus court costs of $277. Now, your probation paperwork is gonna show that you're required to pay a fine. Now, you're required to pay a probation fee of $6 plus your $15 month reimbursement fee of $15, which comes to a total of $137 a month. However, because you are on probation, this probation will be running concurrent with your previous case. You will not be required to pay the probation fee of $60 a month in this case, and the urinalysis fee of $15 a month. You will only be required to pay the fine of $500 plus the court cost of $277 and the reimbursement fee of $15. And your total monthly installments in this case will be $57 a month. Will you be able to pay the $57 each month?
Yes, sir.
And you cannot have any contact with the victim in this case. Let's see. Ashley Rollins. And you will also be required to adhere to the other standard terms and conditions of this probation, and this case will run concurrent with the previous case, cause number M333316. Ms. Roy, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Ms. Roy, I will follow the plea bargain agreement that you have entered into in this case. Now, Ms. Roy, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction in your record, and you may qualify for non-disclosure. You can talk to your attorney, Mr. Adams, about the non-disclosure because he's quite confident in those matters. Now, Ms. Roy, just have a seat in the gallery. Wait for your name to be called. When your name is called, you'll go to the window and follow the directions of the bailiff. You know what? You hadn't finalized anything, right?
No, sir.
Okay, I need to, some of that stuff needed It's sent back to me.
And you have a new one before we go.
I'm putting up my example.
Okay, this is cause number,
Mr. Lee, Judge.
Lee, okay, Travis Lamont Lee. Mr. Lee, your full name is Travis Lamont Lee.
Okay,
How are you doing, Mr. Lee?
pretty good. How about you?
I'm doing fine, thanks for asking. Mr. Lee, you're representing your case by your attorney Thomas Burbank. Attorney Burbank, how are you doing?
Good, fine, Judge.
That's good. Mr. Burbank, what is your announcement in Mr. Lee's case?
I've been discussing this with the district attorney. We believe he may be a good candidate for pretrial diversion. I just asked for a couple of weeks, to see whether or not, he's accepted or not.
Okay, so we're gonna reset this case to October 14th.
We should have.
I was just, so you want to reset sooner?
Judge, if I may, he hasn't been accepted in the pretrial diversion program as of yet. He's going to reach out to Pat to see if he will be accepted in a good candidate.
Okay, let's see, I'm gonna reset this case till September 30th.
That's
Okay, yeah. I must reset it. September 30th of 2024. Mr. Lee, your attorney, and your boss will be given notice of your reset date. Stay in contact with your attorney, your boss, be free to go, and you have a blessed day.
But you know, it's just- and we have one that's in the box.
Okay, this is Robert Lane Bryant. Okay, this is cause number 246 1536, case of style of the state of Texas versus Robert Lane Bryant. Mr. Bryant, is that your full name?
Yes, sir.
How are you doing, Mr. Bryant?
Doing fine, sir.
That's good. Now, Mr. Bryant, you're representing your case by your attorney Tom Burbank. Mr. Burbank, what is your announcement in Mr. Bryant's case?
I believe we're going to have a bench trial, Judge.
That is correct, Judge.
Okay.
I don't know if we are going to need a reset on a date. We have a court reporter or so.
Oh, we may be able to get a court reporter right now.
We waive court reporting.
Okay, let me do this here, Mr. Miss Mosby.
Hey, you're in the big leagues now, Judge.
Okay. You ready? Okay. This is cause number 24 CCCR 1536, case of South State of Texas versus Robert Lane Bryant. Mr. Bryant, is that your full name? Mr. Bryant, how are you doing? I'm doing fine, thanks for asking. Mr. Bryant, you're represented by your attorney, Attorney Tom Burbank. And Attorney Burbank, how are you doing?
Doing fine, Judge.
Now, Mr. Burbank, you signed a waiver of jury trial in this case, is that
We did,
correct?
Judge, and we gave it to, the prosecution to,
I'm sorry, Judge, I was in the back.
Okay. Now, Mr. Bryant, I have before me a waiver of jury trial. And Mr. Bryant, is this your signature on the line as title defendant?
yes, sir, it's mine.
Now, Mr. Bryant, before you signed this document, did your attorney go over this document with you?
Yes.
Did you understand everything that he went over?
Yes.
Is there everything in this document true and correct to the best of your knowledge?
Yes.
Okay, and I have the signature of the prosecutor and defense attorney. Okay, at this time, we'll have a non-jury trial. State, are you ready?
Yes, Your Honor.
Defense, are you ready?
We are ready, Judge.
And Ms. Simmons, would you like to read the information in this case?
Yes, Your Honor. In the name and by authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Robert Lane Bryant, hereafter styled defendant, heretofore on or about May 19th, 2024, did then and there intentionally, knowingly, or recklessly cause bodily injury to Natalie Derrick by striking Natalie Derrick about the head and body with said defendant's hands. It is further presented that at the time of the offense alleged above, Natalie Derrick was a member of the defendant's family or household or in a dating relationship with the defendant against the peace and dignity of the state.
Mr. Bryant, how do you plead?
Not guilty.
Not guilty? And state, would you like to make an open statement?
State waives opening.
Defense, would you like to make an open statement?
We waive.
State, you may call your first witness.
State calls Natalie Derrick.
Natalie Derrick? Derrick. No answers? State, would you like to call his next witness?
State has no further witnesses, but the state would like to make a statement.
You may make your statement.
The state has met with the victim in this case on a numerous amounts of occasions. With that being said, the victim did initiate and make comments to the state where she refuses to cooperate and assist the state moving forward. She's also made statements that she would refuse to come to trial, even with a subpoena. With that being said, she did go ahead and sign a non-prosecution affidavit, and we have that here on file. We have presented it to defense. She has made the statements to not only myself, but also our investigator. State rests.
Okay. Defense?
At this time, Your Honor, the defense has an oral motion for instructed verdict of not guilty for the state's failure to meet their burden of proof.
That motion will be granted. And Mr. Bryant, you are acquitted of these charges. And you should be getting a copy of the judgment in a few minutes. Just have a seat. Your attorney will get the copy of this motion in just a few minutes.
May be excused, Your Honor.
Follow, Bill.
Follow the bill.
Yes. All right.
And may I be excused, Judge?
Yes, you may.
Thank you, Madam Prosecutor.
I
Thank you. She does.
And thank you, Kim.
Yeah, she usually listens to my BS. She has to take it down. You don't have to take it down.
You call me Bradley. I think it's 16. Okay.
Jefferson County Court at law number 2 is back in session. Court is in session and calls number M332968. Case is style the state of Texas versus Max Robert Colbert. Mr. Colbert, is that your full name?
Max Dale Cover, yes,
Max,
sir.
Max Dale Colbert. Okay, Mr. Colbert, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Colbert, you may put your hand down. How are you doing, Mr. Colbert?
Trying to take care of the kids.
I understand. Now, Mr. Colbert, you're representing the case by your attorney, Attorney Langston Adams. Do you waive a record in Mr. Colbert's case?
Yes, sir.
Okay. Mr. Colbert, I have before me a document that is titled Motion to Revoke Probation.
Yes, sir.
This motion was filed by the Jefferson County District Attorney's Office. In this motion, Mr. Colbert, it alleges that you, Max Robert Colbert, was tried on the 28th day of March of 2023 for the offense of terroristic threat of family household, didn't have MA, which I guess is a Class A misdemeanor. And you was found guilty and your punishment was assessed at 180 days confinement in Jefferson County Jail, a fine of $500 in accordance with the provisions of Article 42.12 of the Code of Criminal Procedure, State of Texas, and your confinement was probated for a period of 12 months. And upon the conditions in your probation order, in this motion, it alleges that allegation number one, that the defendant, Max Robert Colbert, has failed to attend and complete anger management program as ordered by the court in violation of condition 17 of your probation order. Is that true or not true?
It's true, Your Honor.
Allegation number two alleges that Max Robert Colbert failed to perform 91 community service hours required as ordered by the court in violation of condition 19 of your probation order. Is that true or not true?
It's true, Your Honor.
Allegation number three alleges that you, Max Robert Colbert, failed to report to Chambers County CSCD, which is a probation officer, as ordered by the court the months of December 2022, January 2023, February 2023, as directed in violation of special amendment dated September 16, 2022. Your probation order, is that true or not true?
True.
And allegation number four alleges that you, Max Robert Colbert, failed to report to the Jefferson County probation by mail or web for the months of February 2023, March 2023, as directed in violation of special amendment dated September 16, 2022 of your probation order. Is that true or not true?
True.
And allegation number five alleges that you, Max Robert Colbert, failed to mail payments for the months of February 2023, March 2023, as ordered by the court in violation of special amendment dated September 16, 2022 of your probation order. Is that true or not true?
True.
Now, Mr. Colbert, are you pleading true to allegations 1, 2, 3, 4, and 5 freely and voluntarily?
Yes, sir.
And are you pleading true because they are true?
Yes, sir.
Mr. Colbert, I also have before me on this tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
I believe so, Your Honor.
You say you believe so?
Yeah, it's recent, last today, right?
Yeah, do you
Yeah,
recognize it?
Yes, sir. I
You
do.
do? Okay.
I'm sorry. I'm teary-eyed. Yeah.
Okay, now, on this document, there's one box that's checked. And that box that's checked states that this is an MTRP, which means motion to revoke probation. On page 2 of the same document, there are a set of initials and MK. They're on a line next to a box that's checked MTRP, which means motion to revoke probation. True to allegations 1, oh, he got 1 through 5. You gotta list each one of them. 1, 2, 3, 4, and 5.
Mhm.
Okay. Now, Mr. Colbert,
Yes, sir.
place your initials on this document,
Yes, sir.
and you're pleading true to allegations 1, 2, 3, 4, and 5. Is that correct?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
That is, Your Honor.
And on the next document, that's titled trial court certification of defendant's right of appeal. You recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that?
I do.
Okay. Okay, now, Mr. Colbert, before you sign and initial these documents, did your attorney go over these documents with you?
Rick,
And did you understand everything that your attorney went over?
I did.
And is everything in this document true and correct to the best of your
Yes,
knowledge?
sir.
Okay. Mr. Colbert, are you a citizen of the United States?
I am.
State,
Other states one.
you have any objections to state's exhibit number 1?
No.
No objection, state's exhibit number 1 will be admitted. And Mr. Adams, you've advised and counsel Mr. Colbert. Is there any evidence that he is currently mentally incompetent to stand his trial?
No.
And Mr. Colbert, your attorney, Mr. Adams, says advised and counseled you. Are you satisfied with his representation?
Very much, sir.
Has he provided full, effective, and competent legal representation?
No, very good, yes, sir.
Okay, Mr. Colbert, I will accept your plea of true to allegations 1, 2, 3, 4, 5. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your probation. And your probation is hereby revoked.
Yes, sir.
Okay. Now, state, this is an unagreed plea bargain agreement. Is that correct?
That is correct, Your Honor.
State, you have any recommendations for, the punishment?
I do, Your Honor. The state previously offered 60 days jail with credit for 17, to which the defendant refused. The state would actually like to ask that the court take into consideration that after speaking with probation, not only today, but also back on July 10th, defendant was non-compliant on all conditions of probation. He has not completed one. He has not even attempted. The state has not only the concern for his failure to comply with probation, but we also have a concern for community safety and victim safety in this matter. And the state asks that you take into consideration up to 180 days.
Okay. Defense.
So basically, Your Honor, I think the state said July of 2023, right?
July 10th of 2024, I spoke with
Okay.
probation as well, to which they're confirming it was I think it was a probation Gilliam. I'm not sure if I'm pronouncing that.
Garrett Gillen?
I'd spoken with him on that day. He confirmed everything that this gentleman's here telling me today, which the defendant was not compliant at all within the terms of his probation.
So, I'm gonna call my client to testify, and I think what I anticipate the evidence is gonna be, Judge, is, and that's why I clarified when she said she spoke in July of 2024. If you look at the allegations, the first one is failure to complete anger management. The other one is the community service. But the one I really want you to focus on is 3. I want you to focus and circle 3 up, highlight 3, whatever you want to do with 3. The reason why I want you to focus with 3 is if you look at the date of that, where it says failure to report to Chambers County, and then if you look at the dates, it's December of 2022, January 23, February of 23, and focus on that. And I'm gonna call him to testify, because what I anticipate the testimony is going to be, Your Honor, is that my client was put on probation according to this motion to revoke on March the 28th of 2023. So he starts that probation in March of 2023, but on the failure to report, it has December of 2022, January of 2023, and February of 2023. My question for the court is, in the first paragraph, when it says Max Robert Cover, defendant in the above style number case, was tried on the 28th day of March 2023 for the offense of terroristic threat. If that was the day that he was tried, then that violation is in December of 2022, before he's even tried. So my question is how are you violating him for something that would have happened before? And I'm just reading word for word. I mean, I'm not changing anything. It says March of 2023. I read that word for word right here. That's March of 2023. But then on the allegation, you saying he violated for something in December of 2022. Well, he wouldn't even been on probation December 2022, because right here you said it happened in March of 2023. So to me, that would be an impossibility. If he's not officially, because that's what it says when he's on probation, March right here of 2023. So, Your Honor, if you look specifically, even on the 4th violation, where it has he failed to report by mail February of 2023, and then the other one, monthly payments begin February of 2023. I just raised the question. Now, like I said, I'm pointing out to the court, if in here you say it don't start till March, so how is he gonna be held accountable for something when you don't start till March, but you're holding them for December and February? That's an impossibility, isn't it?
Okay, State.
I mean, and I'm only reading directly. I read that word for word. It's not like I'm making it up. I'm reading, I mean, that's in, so what document you have before you, the document that you have before you says March the 28th, 2023. But then it has him for allegations before March of 2023. How can you have them both?
All right. State.
Yes, Your Honor. First and foremost, I asked that the defendant stop trying to communicate with me at the side of the bench. He is making contact with me. Secondly, it seems that the original prosecutor on the case, he did have an error that would require an amendment at the request of the court. The defendant actually pled to this case on September 1st of 2022, according to plea paperwork.
Just like, to me, basic rule of law, we all learn in law school, what you plead, you must prove. What she pled, and you gotta go over the plea. It's too late for amendment, because at this point in time, we never started the hearing. What you pled is March the 23rd, March of 2023. That's what's pled. So you can't prove what you pled. And that's in civil law as well as criminal law. What you plead, you must prove. And that's what was pled. So it's too late to now be talking about an amendment. What you plead, you prove. And I read word for word what they pled. I read word for word.
Your Honor, the state would ask that you take judicial notice of the misdemeanor plea agreement form we have, which actually does state the defendant did plead to the agreement on September 1st, 2022. I would also like the court to take into consideration that the defendant just pled true to allegations 1 through 5 and 4.
Well, that's the explanation for that as well. I think that the legal distinction is he is not denying that on those particular dates of December and January, and of February specifically that he failed to report. He's not denying that. What he's saying is that the court should not hold him responsible because in their pleading, they begin March of 2023. So even though factually he may not have reported in Chambers County, legally what they pled, they cannot prove what
Yeah,
they
okay.
pled. And it's a legal distinction, it's from a factual distinction. What they pled, they cannot prove. And since
Okay.
what they pled, they can't prove, we're asking you in this particular case to make a finding in our favor.
I mean, the court can find allegations 3, 4, and 5 not true. But allegations 1 and 2, which don't have dates,
Correct.
plus he pled that he was on probation. I mean, he's pleading that he failed to attend, allegation number 1, he failed to attend and complete anger management.
Right.
Allegation number 2,
Mhm.
that he failed to perform community service.
Right, absolutely true. And my response to you, Judge, on that is, remember I told you.
Well, the issue is whether or not he waived his right once he entered a plea of truth to these allegations. Wait, I mean, yeah, you don't have to say that. That's why you have an attorney.
Sure.
I mean, that if we just think about that for a minute,
Mhm.
because obviously the state cannot prove 3, 4, and 5 based on the
What they
pleas.
pled, correct.
Okay, I understand that. But allegations 1 and 2, which do not, that is no specific date that's attached to allegations 2 and 3. I mean, 1 and 2, 1 and 2.
Right, and on those two, I'm gonna wait. Just wait.
Sorry.
All right, on 1 and 2, remember that's why I told you I wanted you to circle number 3. And the reason I wanted you to circle number 3 is that that's gonna be in line with our defense to 1 and 2. Judge, my short response is, as the state just stated, they offered us 60 days. He refused the 60 days. So when he went open to you, it went from 60 days to now 100.
Well, we in punishment.
Right, so not.
But I think your argument goes back
Right,
to guilt and innocence,
right, and he.
right? Which we had made findings on all 5 allegations
Right,
that they were true. But then you come back, he enters a plea and say, yes, these are true, but now I'm gonna come back on punishment and say, well, they're not true. Because the paperwork is incorrect as to when I started my probation. That's basically his argument.
right, and then that's gonna go into 1 and 2, because what we was gonna ask you to do is to either continue him on supervision. The state has agreed that he has at least 17 days credit in the jail, but I believe there's gonna be more than that, and I'm gonna call my client to explain. Do you see on allegation 1 and 2, you admitted, so there's no reason to call them, because I mean, you admitted, I mean, you said that you did not attend the anger management, you said that you did not do the community service. But remember what I told Judge to focus on number 3? If there's a reason why you didn't go to anger management, there's a reason why you didn't do the community service, and that was what was
I
the
was
why?
incarcerated in Chambers County
You were incarcerated in
for
Chambers
5.5 months, yes, sir.
That's correct. So when you became incarcerated, because remember I told Judge to focus in on number 3, right?
He was incarcerated during the period of his probation?
And I
Not
got
the
time
entire
served.
period, but he got
During some period of his probation, he
Yes,
was
sir.
for 5
incarcerated.
months. He was
Yes,
incarcerated.
sir.
So what we're asking, Judge, is that I think the state looked up 17 days as far as his time in
Here.
Jefferson County.
Yes, sir.
But the state didn't include that on the number 3 for the Chambers County, in Chambers County, he did 5 months.
Yes, sir.
So we talking well beyond, and that was during the time of this probation.
Do we have any information?
This is news.
This is news to the state, Judge. We weren't informed this before we went into open plea.
Oh, okay. Could
With
we,
that knowledge, the plea might very well be time served if we can confirm that.
We have to confirm.
okay, can we take the time to confirm it?
Yeah.
Okay,
It's just.
so what we're gonna do, we're just gonna be in recess to get a state time to try to confirm that you might have to give them the dates.
Give him to his attorney. and he can-
Yeah, okay, you may have to give them to your attorney could give them to,
I can't remember off the top of my
I,
head,
well,
but it was, I wanted to do all this stuff.
well, just hold on, don't say anything about your case until
Sorry.
your attorney gives you the green light.
The
And,
bo-
and so what we need to do is, they can contact Chambers County and find out when you were there. That's not a problem. That's just a phone call that they can make,
Yes.
which is gonna take a few minutes.
I'm gonna step to the back, see if I can get
Okay.
someone on phone during lunch.
All right,
hour.
we'll be in recess on that. Where did Mr. LeBlanc go?
That I don't have, Judge.
Okay. Okay. Oh, there he is.
Can we approach on Mr. LeBlanc's case? Can we-
LeBlanc.
Yeah.
Here.
Okay.
Todd, ready?
Mr. LeBlanc?
Yes, sir.
Mr. LeBlanc? This is cause number 24 CCCR 0621. Case is style of state of Texas versus Nicholas Benjamin Beeman. Mr. Beeman, how are you doing?
Pretty good.
That's good. Mr. Beeman, you're represented by your attorney, Attorney Tyler LeBlanc. Attorney LeBlanc, how are you doing?
Good, thanks, Brad.
And you welcome. Now, Mr. LeBlanc, what is your announcement in Mr. Beeman's case?
Judge, we need a little more time to go over some things. You know, I've been talking about it, and I kind of want to inquire with the court if we decide to possibly pursue a motion to suppress and that be dispositive with the court. I don't know if this court's, I don't recall ever having done that in this court. I don't know if we could do that, but we're not at that stage yet. He and I have been talking about it, and that might be the route we go. If and I don't know if you'd said it, I guess you would say it's special, because we would need a trial, we would be.
Yeah, I mean, we could try to set it on a pretrial conference docket,
Yeah, and then it would be dispositive.
but you would have to file your motion. Yeah,
Yeah, and that, I don't want to do that until.
yeah, this case was just filed, so this is not an
Yes.
old case.
Yes,
Well,
Judge,
actually,
it's our
yeah,
first
for
time.
some reason they held it for a while before they filed it. Because it's only, yeah,
Discovery access has been made available to you in both these cases.
Thanks. And this
Okay.
is my first day here our first time in court
Okay.
in this case, so.
so what we'll do, let me do this here. I'm gonna reset this case till October 2nd. Okay, what's the matter?
Oh, it's his birthday.
That's my mother's, okay, okay. Well, let's do this here,
That's fine, I'll be on vacation that week.
huh?
He'll be on.
I'll be on vacation.
Yeah, okay, we'll, huh?
October second is a Wednesday. You want to put on pre-trial, that have to be on the Monday.
Oh. Let me read.
October 7th?
The 7th, so it'll be on the 7th. Yeah, hold on, October 7th,
If we might have yours, working on the right.
it'll be October 7th of 2024.
When you submit that motion, can you email me a copy?
Oh, absolutely. I'll make-
Okay.
make sure.
Yeah, you should get e-served too.
And sometimes we do, sometimes we.
You don't, okay. And so,
Make sure.
this case will be reset to October 7th, 2024. Your attorney and your bondsman will be given, your attorney and your bondsman will be given notice of your reset. Once you're free to go, stay in contact with your attorney and your bondsman.
Okay.
Okay, here we go. Let's go ahead and back. Court is back in session and calls number M 332-968, case of style of state of Texas versus Max Robert Culver. Mr. Culver, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Culver, now, again, you was previously sworn in, and also, I'm going to read to you a motion that was filed by the Jefferson County District Attorney's Office. Actually, it's the first amended motion. That was, just trial amendment that was filed today. Mr. Adams, do you have any objections
No,
to this
sir.
first amended motion?
No, sir.
Now, Mr. Adams, do you waive a record?
Yes, sir.
Okay, Mr. Culver, in the state first amended motion to revoke probation, it alleges that you, Max Robert Culver, in the above style and number cause, which is cause number M 332-968, that on the first day of September of 2022, that for the offense, that you was tried for the offense of terroristic threat of family, household, and that's class A misdemeanor. And on that date, you was found guilty and assessed punishment for a term of 180 days confinement in Jefferson County Jail, a fine of $500 in accordance with the Article 42.12 of the Texas Code of Criminal Procedure. Your confinement was probated for a period of 12 months. In this motion, there are 5 allegations. State, are you abandoning allegations 3, 4, and 5?
That's correct.
Mr. Culver, the state is abandoning allegations 3, 4, and 5. They will only be proceeding on allegation number 1 and 2. Allegation number 1 alleges that you, Max Robert Culver, has failed to attend and complete an anger management program as ordered by the court in violation of condition 17 of your probation order. Is that true or not true?
True.
Allegation number 2 alleges that you, Max Robert Culver, failed to perform 91 hours of community service as ordered by the court in violation of condition number 19 of your probation order. Is that true or not true?
True, Your Honor.
Now, Mr. Culver, are you pleading true to allegations 1 and 2 freely and voluntarily?
Yes, sir.
And are you pleading true because they are true?
Yes.
Mr. Culver, I also have before me a document that is labeled as State's Exhibit number 1, which is the misdemeanor plea admonishment. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials on a line next to a box that says check motion to revoke probation, which is the MTRP allegations 1 and 2. And is this your,
Correct.
are these your initials?
Yes, sir.
On page 3 of this document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, it's titled trial court certification to defendant's right of appeal. You recognize this document?
I do, Your Honor.
And is this your signature on the line that's titled
It is.
defendant? At the top of this document, there are 2 boxes checked. The first box check states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Understood.
The second box says check states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
I do, Your Honor.
Now, Mr. Culver, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, Your Honor.
And did you read and understand everything he went over?
I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Culver, are you a citizen of the United States?
Different states one.
Any objections?
No.
No objections. State's Exhibit number 1 will be admitted. And Mr. Adams, you've advised and counseled Mr. Culver. Is there any evidence that he is currently mentally incompetent to stand trial?
None.
And Mr. Culver, your attorney, Mr. Adams, has advised and counseled you. Are you satisfied with his representation?
Very much.
Has he provided full, effective, and competent legal representation?
Very much.
Mr. Culver, I will accept your plea of true to allegations 1 and 2. I will find that you are mentally competent to stand trial. I'll also find that your plea of waivers were freely and voluntarily given. I'll also find that there is sufficient evidence to revoke your probation, and your probation is hereby revoked. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement is, for plea of true to allegations 1 and 2, state is offered 130 days time served for about sex or entirety.
Okay. Mr. Culver, the state is offering that you serve 130 days in Jefferson County Jail. However, you not be required to serve any more time in Jefferson County Jail in this case because you already served 130 days in the Jefferson County Jail. You'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Colbert, do you understand the state's offer?
I do.
Do you think that the state's offer in
Very
your
fair.
case is fair and just?
Yes, I do.
And do you understand? And so, Mr. Colbert, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Colbert, just have a seat. Wait for your name to be called by the court coordinator. Once your name is called, you're gonna follow the directions of the bailiff. Once you follow the directions of the bailiff, you'll be free to go. You have a blessed day.
Appreciate you.
Okay?
Your Honor.
Okay? Okay, we'll see you later. We'll see you tomorrow, huh?
Yeah, I got the, jail one, right?
Yeah,
So we'll make it happen.
okay,
Y'all take it easy.
okay. We'll see you later.
Hello?
Let's see. This is her. Oh. This is the video conference where she could appear by Zoom. Like this has to be signed out of state.
Oh, okay. Are we gonna do that? Oh, okay.
Okay, thank you.
I had to read the title of it to at least make sure of what I'm saying.
Oh, yeah. This is giving all right. Okay, this is the court is in session with the non-disclosure docket. You have, hold on a minute.
Reveal. You can be seen.
Okay, this is cause number 23 CCC V 0140. The style is the state of, hold on, let me see how the case. The style is in the matter of Latanya K. Hickman, FKA, which is formerly known as Latanya K. Matthews. And Ms. Matthews is appearing via Zoom. Is that correct?
Yes,
Okay. How are you doing, Ms. Matthews?
I'm Miss Hickman, but I'm okay.
Oh, okay. Now, Ms. Hickman, I have before me a document that is titled Joint Request for a Plea and or Sentencing by Video Conference under Texas Code of Criminal Procedure, Articles 27.18. This gives you the right to appear via Zoom. It is signed by you and the state assistant district attorney, and the court is going to approve this request. Let's see.
Thank you.
You're welcome. Okay, now Ms. Hickman, in this case, I have before me a motion, a petition for order of non-disclosure. And prior to the hearing started, the State Assistant District Attorney. And I was reviewing this document. Now, in this document, the caption states that in the matter of LaTanya K. Hickman, FKA, which is formerly known as LaTanya K. Matthews. And before the court go any further, in this case, the court will take judicial notice of the criminal case, cause number 026836. And in that case, I have an information that was filed by the Jefferson County District Attorney's Office. And in this information is titled "The State of Texas versus LaTanya Hickman Matthews." Now, Ms. Matthews, you are the one and same LaTanya Hickman Matthews, is that correct?
That's correct.
Okay. Now, you can make what we call a trial amendment. Trial amendment means that you can amend your pleadings to reflect your name of LaTanya Hickman Matthews on this petition as well. Do you understand?
Yes.
Okay, because I would imagine that most of the paperwork involved in this case is under LaTanya Hickman Matthews. And so it's not only in the records in the county, but also the records that the state may have as well. Okay. And state.
Okay. And mhm.
Okay, go ahead on.
I talked when they set this up, they told me the same thing that you're saying now. And so when it was sent over to the court, she told me that she would have to have it with my maiden name and my married name. But I'm divorced since. So if it has LaTanya Hickman Matthews, she said that's the way that it should stay. They explained that to me when I first filed this.
Okay, but you don't have LaTanya Hickman Matthews on your paperwork. That's what I'm saying. And so when you make an amendment, you are adding LaTanya Hickman Matthews on the paperwork. Do you understand?
Yes, understood.
Okay, and the state, do you have any objections?
No objection, Your Honor.
Okay, so the state does not have any objections to that being added, and I'm writing it in as we speak. Okay, now Ms. Hickman, would you please raise your, Ms. Matthews, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Now, I know, Ms. Matthews, that you are pro se, which means that you do not have an attorney representing you, you're representing yourself. And we usually ask the attorneys to prove up the case. And when I say prove up the case, the attorneys basically look at the petition and basically state what's in the petition as being true. And then the state could ask some questions as well.
Okay, for this non-disclosure, maybe I'm not understanding exactly because when I spoke with the company, I went through a company just to get this expunged, and they told me that this would just be a easy process for me to make sure because it's over 10 years old. And so I don't even recall everything that happened during that time, but whatever I need to do just to.
Do you have a copy of the petition before you?
Yes, I do.
Okay. So the court also has a copy of that petition, and the court has a copy of the misdemeanor case as well. The court has already taken, if the court has not, the court will be taking judicial notice of that petition. In essence, everything that's in your petition basically comes out of the criminal case file.
Right.
Okay? For example, your name, Latanya Hickman Matthews. Okay, that was in the misdemeanor file. Now,
Mhm.
what I can do is this. Now, Ms. Hickman, you've previously been sworn in. Now, is everything in this petition true and correct to the best of your knowledge?
To the best of my knowledge, yes.
Now, state, do you have any questions?
No, Your Honor.
Okay, you have no objections?
We have no objections to the entry of this non-disclosure.
Okay, now, Ms. Matthews, the court is going to, okay, the court is going to grant your non-disclosure because the court has reviewed it. And pursuant to Article 411.0725, you meet the eligibility requirements for a non-disclosure. And so the court will be granting the non-disclosure in this case. And just for the record, now you're required to show that it is in the best interest of justice that you received this non-disclosure. Could you explain, just make a statement as to why you think it would be in the best interest for you for the court to grant this non-disclosure?
I believe that for my interest, I am a business owner and I'm moving back to Texas. I'm currently outside of Texas. I'm no longer married. And the situation that happened for this, I was married, the person that I was married to involved me in this. And that's the reason why I feel like I need to have this non-disclosed in order to, you know, keep my name, keep everything straight so that I don't have any problems moving forward. My life has totally changed. And without that person, I think that I'm better.
And you have not committed any other crimes, is that correct?
Correct.
Okay. Okay, State, you have anything?
Nothing, Your Honor. We would just note that we join with Ms. Matthews in this matter, and we could not locate anything that would indicate that she has any other subsequent criminal history other and ignoring Class C misdemeanors, but fine only. And we would ask that the court enter the non-disclosure order.
Okay. Ms. Matthews, congratulations. The court is going to sign an order with the amendments on the non-disclosure. Okay, and then this will conclude this hearing. You're free to.
All right. Well,
free to
thank you
go.
so much, Justice Holmes.
All
You're
right,
welcome.
and you have a blessed day, and you should be able to get a copy of this order probably, let's say by Friday, because once I make the corrections and once we file it, it's going to take about a day or so for it to get into the system. Okay.
Okay, no problem. No
All
problem.
right. You have a blessed day.
You too. Thank you.
You're welcome.
Bye-bye.
That's one down, Your Honor.
Okay. Now we did 2 this morning.
Oh, you did 2 this morning?
Mhm.
Okay, good.
Yeah. And that was Mr. Macon's case.
Mr. Macon,
Yeah.
okay. What's the
Okay.
price?
Okay, the court is in session and cause number 23CCCV 0269. The case is styled, the case is styled in the matter of D'Angelo Lee Fontanet. Mr. Fontanet, is that your full name?
Yeah.
Mr. Fontanet, would you please raise your right hand? Mr. Fontanet, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Fontanet, you may put your hand down. How are you doing, Mr. Fontanet?
I'm doing okay.
Well, that's good. Now, Mr. Fontanet, you are representing yourself, in this case, you are pro se. And I have before me this petition for order of non-disclosure under section 411.0725 of the Texas, Government Code. Now, Mr. Fontanet, are you ready to proceed?
Yeah.
Okay, now state, do you have any objections to Mr. Fontanet's petition of order of non-disclosure?
No, Your Honor, we do not have any objection, and we would stipulate to the factual allegations that Mr. Fontanet made in his petition for non-disclosure.
Okay, so Mr. Fontanet, the court will take judicial notice of your the misdemeanor case, cause number 281010. And the court will ask this question. Now, Mr. Fontanet, this has been close to 14 years that you was discharged off of deferred adjudicated probation. Now, during that 14-year time period, could you just give the court an idea of what you've been doing, whether or not have you committed another crime since then?
No, sir.
Okay, so have you been working?
Yeah, I've been working, doing a lot of construction work,
Okay,
raising my kids.
okay, how many kids do you have?
I have 4.
Okay, that's a great thing. Now, if you did not have this non-disclosure, would that affect your ability, for one, to get employment?
I think so, like it will affect.
Okay,
Later on in life with jobs.
okay,
That's why let's get it. This,
okay. You want to just get the, okay, I understand that. Now, Mr. Fontanet, the court is gonna grant this non-disclosure. And you should be able to get a copy of this non-disclosure. I'll be signing the order. I think there's an order in here. Oh, here it is. Okay. So, on the 14th day of August of 2024, the court is gonna find that, court is gonna grant this petition, and the non-admissible hearing was requested. We conducted the hearing on today's date. 2024. So the Texas 411.0725, and the court is going to grant this order. Did you finalize anything? Okay, good. Oh, and there's a spot on here for you to sign. This is gonna be filed today, so you should be able to get a copy of this order at least by tomorrow. Okay, so I see that you have some support here with you. Who do you have?
my mom
Your mother and your oldest son? Okay, what's your oldest son name?
and
Dylan? Okay, that's good. Now, yeah, that's one thing about mamas, they stay with you. That's right.
Yeah, I was going to like, I want to come.
Yeah, well, that's a good thing. You know, that's a good thing. You got your mama still here with you. Yeah, I know, ma'am, he didn't listen to everything that you said. Well, I have children too, so I know, and I was a child myself, so I know. But anyway, what he's getting here today is a good thing. He's putting this behind him, and that's a good thing. And just take care and love on those kids that you have. Okay, that's the best thing that you can do. Okay, it's better than money. Okay, that nurturing is a whole lot better than money. So congratulations, Mr. Fontenette. You're free to go. You have a blessed day, and y'all have a blessed day as well.
Thank you.
You're welcome.
Nice meeting you.
I'm gonna have to get you to sign this here.
do that other one as well.
Yeah, because, yeah.
You're welcome. Congratulations.
I just have to make sure her name is.
Mhm.
Start to say, I wish, he Okay, so this is, cause numbers. Oh, this was old. Cause number 136678. Case is styled State of Texas versus Jason Paul Hoffmeyer. And Jason Paul Hoffmeyer filed a petition for non-disclosure under the Article 411.072 of the Government Code. State, you have any objections to Mr. Hoffmeyer's petition for non-disclosure?
No, Your Honor.
Okay, so the court is going to grant, well, let's do this before the court grants the petition. The court is going to take judicial notice of the misdemeanor file. Cause number 315442. And then the court is going to grant the petition for non-disclosure for Jason Paul Hoffmeyer.
Your Honor.
All right,
All right,
and that's it.
they've got that taken care of. All right.
Okay, that's it.
Now we got bond forfeitures.
Yes.
You
want the last?
Yeah.
If there's any cash bonds. Surety bond, forfeiture document.
You got theft in there.
And you don't have to call them individually.
What is identified?
Or that's what we've been doing, is just calling out.
The name, you got the name. Down to,
And here's your book if you want. You wanted to bring them away.
yeah,
Okay, couldn't remember.
we've got it down now to where we're pretty current.
Yes,
Okay.
We're not behind at all.
no.
Thank you.
You like to proceed?
Yes, Your Honor.
You may proceed.
Your Honor, we would ask that the court take judicial notice of the court's bond forfeiture docket for August 14th, 2024.
The court will take judicial notice of the bond forfeiture docket for August 14 of 2024.
And we would request that the court take judicial notice of the court's files in each one of the identified cases that are on the court's bond forfeiture docket.
The court will take judicial notice of each case that are on the bond forfeiture docket.
And we would ask that the court enter judgment according to the court's docket.
Judgment shall be entered.
And we will submit written judgments for the court signature.
Okay.
All right.
And this will conclude the hearing of the court's bond forfeiture docket on August 14th, 2024 in County Court Order number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Are you excused?
Thank you, Your Honor. Okay. That's the one I wrote on.